Education Act 1902 to Edward the 7th, C42, Section 7, subsection 1. The local educational authority shall maintain and keep efficient all public elementary schools within their area which are necessary, and have the control of all expenditure required for that purpose, other than expenditure for which, under this Act, provision is to be made by the managers, but in the case of a school not provided by them, only so long as the following conditions and provisions are complied with. A. The managers of the school shall carry out any directions of the local educational authority as to the secular instruction to be given in the school, including any direction with respect to the number and educational qualifications of the teachers to be employed for such instruction, and for the dismissal of any teacher on educational grounds, and if the managers fail to carry out any such direction, the local educational authority shall, in addition to their other powers, have the power themselves to carry out the direction in question as if they were the managers, but no direction given under this provision shall be such as to interfere with reasonable facilities for religious instruction during school hours. B. The local educational authority shall have power to inspect the school. C. The consent of the local educational authority shall be required to the appointment of teachers, but that consent shall not be withheld except on educational grounds, and the consent of the authority shall also be required to the dismissal of a teacher, unless the dismissal be on grounds connected with the giving of religious instruction in the school. D. The managers of the school shall provide the schoolhouse free of any charge, except for the teacher's dwelling house, if any, to the local educational authority for use as a public elementary school, and shall, out of funds provided by them, keep the schoolhouse in good repair, and make such alterations and improvements in the buildings as may be reasonably required by the local educational authority, provided that such damage as the local authority consider to be due to fair wear and tear in the use of any room in the schoolhouse for the purpose of a public elementary school shall be made good by the local educational authority. E. The managers of the school shall, if the local educational authority have no suitable accommodation in schools provided by them, allow that authority to use any room in the schoolhouse out of school hours free of charge for any educational purpose, but this obligation shall not extend to more than 3 days in the week. 3. If any question arises under this section between the local educational authority and the managers of a school not provided by the authority, that question shall be determined by the Board of Education. Section 16. If the local educational authority fail to fulfil any of their duties under the Elementary Education Acts 1870 to 1900, or this Act, or fail to provide such additional public school accommodation within the meaning of the Elementary Education Act 1870 as is, in the opinion of the Board of Education, necessary in any part of their area, the Board of Education may, after holding a public inquiry, make such order as they think necessary or proper for the purpose of compelling the authority to fulfil their duty, and any such order may be enforced by mandamus. Trademarks Act 1905, 5 Edward VII, C15, Section 60, subsection 1. Subject to the provisions of this Act, the Board of Trade may from time to time make such rules, prescribe such forms, and generally do such things as they think expedient. A. For regulating the practice under this Act. B. For classifying goods for the purposes of registration of trademarks. C. For making or requiring duplicates of trademarks and other documents. D. For securing and regulating the publishing and selling or distributing in such a manner as the Board of Trade think fit of copies of trademarks and other documents. E. Generally for regulating the business of the office in relation to trademarks and all things by this Act placed under the direction or control of the Registrar or of the Board of Trade. 2. Rules under this section shall, whilst in force, be of the same effect as if they were contained in this Act. 3. Before making any rules under this section, the Board of Trade shall publish notice of their intention to make the rules and of the place where copies of the draft rules may be obtained in such manner as the Board consider most expedient, so as to enable persons affected to make representations to the Board before the rules are finally settled. 4. Any rules made in pursuance of this section shall be forthwith advertised twice in the Trademarks Journal, and shall be laid before both Houses of Parliament, if Parliament be in session at the time of making thereof, or, if not, then as soon as practicable after the beginning of the then next session of Parliament. 5. If either House of Parliament, within the next 40 days after any rules have been so laid before such House, resolve that such rules or any of them ought to be annulled, the same shall, after the date of such resolution, be of no effect, without prejudice to the validity of anything done in the meantime under such rules or rule, or to the making of any new rules or rule. Patents and Designs Act 1907, 7 Edward VII, C29. Section 86, subsection 1. The Board of Trade may make such general rules and do such things as they think expedient, subject to the provisions of this Act. A. For regulating the practice of registration under this Act. B. For classifying goods for the purposes of designs. C. For making or requiring duplicates of specifications, drawings, and other documents. D. For securing and regulating the publishing and selling of copies at such prices and in such manner as the Board of Trade think fit of specifications, drawings, and other documents. E. For securing and regulating the making, printing, publishing and selling of indexes to and abridgments of specifications and other documents in the Patent Office, and providing for the inspection of indexes and abridgments and other documents. F. For regulating, with the approval of the Treasury, the presentation of copies of Patent Office publications to patentees and to public authorities, bodies and institutions at home and abroad. G. For regulating the keeping of the register of patent agents under this Act. H. Generally for regulating the business of the Patent Office and all things by this Act placed under the direction or control of the Comptroller or of the Board of Trade. 2. General rules shall, whilst in force, be of the same effect as if they were contained in this Act. 3. Any rules made in pursuance of this section shall be advertised twice in the official journal to be issued by the Comptroller, and shall be laid before both Houses of Parliament as soon as practicable after they are made, and if either House of Parliament, within the next 40 days after any rules have been so laid before that House, resolves that the rules, or any of them, ought to be annulled, the rules, or those to which the resolution applies, shall, after the date of such resolution, be of no effect, without prejudice to the validity of anything done in the meantime under the rules, or to the making of any new rules. Small Holdings and Allotments Act 1908. 8 Edward VII, c. 36, section 39, subsection 1, where a council, county, borough, urban district or parish council, propose to purchase land compulsorily under this Act, the council may, subject to the provisions of Part 1 of the first schedule to this Act, submit to the Board of Agriculture and Fisheries an order putting in force as respects the land specified in the order the provisions of the Lands Clauses Acts with respect to the purchase and taking of land otherwise than by agreement. Where a council propose to hire land compulsorily, the council may submit to the board an order for the compulsory hiring of the land specified in the order for a period not less than 14 nor more than 35 years, and the provisions of Part 1 of the first schedule to this Act shall apply to the order in like manner as it applies to an order for compulsory purchase, with the substitution of hiring for purchase, and with the modifications set out in Part 2 of the schedule. 3. An order under this section shall be of no force unless and until it is confirmed by the Board, and the Board may, subject to the provisions of the first schedule to this Act, confirm the order either without modification or subject to such modifications as they think fit, and an order when so confirmed shall become final and have effect as if enacted in this Act, and the confirmation by the Board shall be conclusive evidence that the requirements of this Act have been complied with, and that the order has been duly made and is within the powers of this Act. 5. In determining the amount of any disputed compensation under any such order, no additional allowance shall be made on account of the purchase or hiring being compulsory. First Schedule Part 1, subsection 1. The order shall be in the prescribed form and shall contain such provisions as the Board may prescribe for the purpose of carrying the order into effect and of protecting the council and the persons interested in the land, and shall incorporate, subject to the necessary adaptations, the Lands Clauses Acts and sections 77 to 85 of the Railway Clauses Consolidation Act 1845, but subject to this modification, that any question of disputed compensation shall be determined by a single arbitrator appointed by the Board, who shall be deemed to be an arbitrator within the meanings of the Lands Clauses Acts, and the provisions of those Acts with respect to arbitration shall, subject to the provisions of this schedule, apply accordingly. Part 2. 3. The determination of A. The amount of the rent to be paid by the council for the land compulsorily hired. B. The amount of any other compensation to be paid by the council to any person entitled thereto in respect of the land or any interest therein, or in respect of improvements executed on the land or otherwise. And C. Where part only of a holding held for an unexpired term is hired, the rent to be paid for the residue of the holding during the remainder of that term shall, in default of agreement, be by valuation by a single valuer appointed by the Board, provided that, if the land hired is in occupation of a tenant, he may, by notice in writing served on the council before the determination of his tenancy, require that any claims by him against the council which, under the Agriculture Holdings Act 1908, might be referred to arbitration under that Act, shall be so referred, and in such case those claims shall be determined by arbitration under that Act, and not by valuation under this Act. Housing, Town Planning, etc. Act 1909, 9 Edward VII, c. 44. Section 17, subsection 1. It shall be the duty of every local authority to cause to be made from time to time inspection of their district with a view to ascertain whether any dwelling house therein is in a state so dangerous or injurious to health as to be unfit for human habitation, and for that purpose it shall be the duty of the local authority and of every officer of the local authority to comply with such regulations and to keep such records as may be prescribed by the local government board. 2. If, on the representation of the medical officer of health, or of any other officer of the authority, or other information given, any dwelling house appears to them to be in such a state, it shall be their duty to make an order prohibiting the use of the dwelling house for human habitation, in this Act referred to as a closing order, until in the judgment of the local authority the dwelling house is rendered fit for that purpose. 3. Notice of a closing order shall be forthwith served on every owner of the dwelling house in respect of which it is made, and any owner aggrieved by the order may appeal to the local government board by giving notice of appeal to the board within 14 days after the order is served upon him. 6. The local authority shall determine any closing order made by them if they are satisfied that the dwelling house, in respect of which the order has been made, has been rendered fit for human habitation. If on the application of any owner of a dwelling house the local authority refuse to determine a closing order, the owner may appeal to the local government board by giving notice of appeal to the board within 14 days after the application is refused. Section 39, subsection 1. The procedure on any appeal under this part of this Act, including costs to the local government board, shall be such as the board may by rules determine, and on any such appeal the board may make such order in the matter as they think equitable, and any order so made shall be binding and conclusive on all parties, and where the appeal is against any notice, order, or apportionment given or made by the local authority, the notice, order, or apportionment may be confirmed, varied, or quashed as the board think just, provided that a. The local government board may at any stage of the proceeding or appeal, and shall, if so directed by the High Court, state in the form of a special case for the opinion of the court any question of law arising in the course of the appeal, and b. The rules shall provide that the local government board shall not dismiss any appeal without having first held a public local inquiry. First schedule, subsection 1. Where a local authority proposed to purchase land compulsorily under this Act, the local authority may submit to the board an order putting in force as respects the land specified in the order the provisions of the Lands Clauses Acts with respect to the purchase and taking of land otherwise than by agreement. 2. An order under this schedule shall be of no force unless and until it is confirmed by the board, and the board may confirm the order either without modification or subject to such modification as they think fit, and an order when so confirmed shall, save as otherwise expressly provided by the schedule, become final and have effect as if enacted in this Act, and the confirmation by the board shall be conclusive evidence that the requirements of this Act have been complied with, and that the order has been duly made and is within the powers of this Act. 3. In determining the amount of any disputed compensation under any such order, no additional allowance shall be made on account of the purchase being compulsory. 4. The order shall be in the prescribed form, and shall contain such provisions as the board may prescribe for the purpose of carrying the order into effect, and of protecting the local authority and the persons interested in the land, and shall incorporate, subject to the necessary adaptations, the Lands Clauses Acts, except Section 127 of the Lands Clauses Consolidation Act, 1845, and Sections 77 to 85 of the Railways Clauses Consolidation Act, 1845, but subject to this modification, that any question of disputed compensation shall be determined by a single arbitrator appointed by the board, who shall be deemed to be an arbitrator within the meaning of the Lands Clauses Acts, and the provisions of those acts with respect to arbitration shall, subject to the provisions of this schedule, apply accordingly.